Good afternoon, Justice Mabindla-Boqwana, sorry.
Good afternoon, Chief Justice, and good afternoon to the commissioners.
We are sorry to have kept you waiting all day, but it's just one of those days. You don't have luck, it seems.
Not a problem, Chief Justice.
How are you?
Very well, thank you, and how are you?
Fine, thanks. All right, are you comfortable over there? Is that a nod?
Chief Justice, thank you.
Okay. Justice Boqwana, just forgive me. Well, you've always said you don't mind being called one or both. Both are your names, so yes. I'm saving time. Your name is too long.
No problem, Chief Justice.
You obtained 2 degrees from the University of Wits.
That's correct, Chief Justice.
In 1996 and 1998.
Yes.
What did you do thereafter? Just briefly, in your own words.
After that, I completed articles at the Nace Rates Attorneys, and thereafter I went to join Samson Oaks Higgins Attorneys as an associate. While I was there, I was headhunted or asked by Anglo Gold Ashanti to join them as a labor lawyer or as labor law counsel for the Act as well as the Labor Relations Act. I'm not sure if I've mentioned it. And so many companies were aligning their policies with the legislation to make sure that they are in compliance. So in our department, what we did is to develop policy for the company and advise on strategy. And we also were part of the negotiation team that negotiated and involved in collective bargaining with the trade unions. At the time, the Mine Workers Union, National Union of Mine Workers, Solidarity, I think, and UWASA, those were the main trade unions at the time. And so we had to do a lot of labor relations between the unions and the company and advising the company as such. And we also represented the company. When I say we, it was myself and the colleagues that were in the department. We represented the company at the Chamber of Mines, which is an association where the mines were, and they would devise national policy for the mines and also negotiate at that level with the trade unions on wages and all those things. I was also in charge of giving opinions, legal opinions on employment matters, and also interacting with lawyers outside because I was in-house counsel. I would also appear at the CCMA in the labor court because that was allowed, being an employee of the company, representing the company, to do so. So that generally was my role. And I also was in charge of devising, if I can recall, the disciplinary code and procedure of the company, as well as the anti-sexual harassment policy of the company at the time. And we did road shows and workshops in different regions and mines. So in a nutshell, that's what I can say. Oh yeah, while I was there, I think it's important to mention this, I was asked to be a trustee in the board of the Mine Workers Provident Fund, which I chaired a few years or a year later, if I recall. So being a chair of the fund, I would collaborate with administrators, with asset managers, and a whole host of stakeholders that had the relationship with the fund. And I also got to be involved in the Institute of Retirement Funds when I was there as well. That is, as a board member. The Institute of Retirement Funds is an institute where retirement funds, administrators in the country collaborate, and I was part of a number of committees in those structures.
Either as a member or in the executive?
Yes, either as a member. And also, I forgot to mention SASLO, that I was in the National Executive Committee of SASLAW. I was elected there when I was still at Sampson Oaks Higgins Attorneys to be in the National Executive Committee of SASLAW, and I was there for a number of years, and I became the vice chairperson of the Gauteng chapter at some point.
Yeah, I count 11 years of your involvement with it.
Yes, it was a long time.
All right. Then you decided to strike it off on your own.
Yes, then I ventured on my own. I think like many young people do, you go and venture and try things and see how it goes. And when I went to Port Elizabeth, I started a company called Lwazi Consulting. In fact, its full name was Nolwazi Investment Holdings, trading as Lwazi Consulting, because as a startup, I would do something that I was trained to do, which is to consult on employment matters and do training for companies. And also at the same time, I was in the panel of Dogiso. I'm sure a lot of people know Dogiso dispute settlement. So we would get drawn from the panel to go and arbitrate matters, to mediate, to facilitate whatever that would be needed at the time by the clients.
That didn't last very long. You started another enterprise, Hluma Business.
Yes, I had a collaboration between myself and another partner. We started Hluma Business and Labor Services. We did similar work, but my partner was more human resource inclined. And so he devised policies for clients on that line, and mine was the labor side of things. But because of his illness, we couldn't continue with the firm. Then I had an appetite of wanting to go back to practice and focus on pension law and no longer labor law this time, because that's the area that I was now involved in.
Mm-hmm. So you joined TIPA Incorporated Attorneys as director and senior attorney? Yes,
director and senior attorney, and specifically formed a company, a branch of the company in Port Elizabeth, which I led and focused on, but I was in charge of the litigation for the entire firm, because we had 3 branches. We had the main office in Johannesburg, because this is where most of the pension funds and administrators are located, and also in Cape Town, because that's where others are. And so we had Johannesburg, Cape Town, and the little branch in Port Elizabeth.
All right. Then you were lured to the bench.
Yes, one day.
When?
One day in 2011, Judge President Mlambo gave me a call and asked me to come and act at the Labor Court in 2011. I think it must have been September or so. I can't recall.
And the rest is history.
The rest is history. Yeah. And then I went to the High Court.
You acted at the Labor Court?
Yes, acted at the Labor Court, I think the last quarter of the last term of 2011. Then I was called again to act in 2012 from the second term, if I'm not mistaken. And then directly from there, I was called to act in the High Court. So I acted in the High Court right through from January 2013 until I was appointed on the 2nd of December 2013.
Mm-hmm. And at some stage, you became involved in the Competition Appeal Court?
Yes, I became involved in the Competition Appeal Court. In 2015, I was asked by Judge President at the time, Dennis Davis, to go and act in the Competition Appeal Court, and I was appointed by this body, recommended by this body in 2016 and appointed in 2017.
Mm-hmm. And I recall that the vision was for you to take over that court as its Judge President when Judge President Davis retired.
Yes, I was
until the
told.
SCA poached you.
Yes, I was informed of that.
Mm-hmm. So how long have you been at the Supreme Court of Appeal?
When you called me, when you were still the Chief Justice as President, that was from the 1st of April 2020. Then I continued to act until my appointment on the 1st of July 2021. Mm-hmm. So I've been there for 4 years.
Mm-hmm. And apparently you've done so well there that right at the moment you were busy filling in your JSC questionnaire for this position, the former Chief Justice was contemplating inviting you to go and act at the Constitutional Court, but we'll get back to that. You've written a number of judgments as a judge in all these courts in which you've sat.
Yes, Chief Justice.
About how many would you say on estimate?
You mean all judgments?
All your judgments.
The ones that I could locate, because I traditionally would send my judgments to sub-plea, although that was not something that was done as a matter of course in the High Court. Judges choose whether or not to send the judgments there. But so I was able to locate about 163, I think. I can't remember, but I put an annexure in my questionnaire, Annexure C and Annexure D. Annexure C deals with the reported judgments in all the courts, and then Annexure D deals with all judgments that I could locate.
How many of those reported? Doesn't have to be an exact number.
40-something. Like
Right.
43 or, yeah, I think.
Okay.
And I saw two more after I had handed in my application that they were also reported from the SCA.
How long were you a judge at the Western Cape Division of the High Court?
I was a judge there for 7 years, Chief Justice.
Okay. Your career trajectory has been it's a strange one. You were offered a leadership position at the competition courts, and you chose to go to the appellate division, the Supreme Court of Appeal. Now you had an opportunity to go to the Apex Court, well, albeit in an acting stint, and you decided to go back to the High Court. That makes sense to me. Why would a Supreme Court of Appeal justice, one doing well for herself, want to go back to the High Court, to a seemingly, well, not seemingly, to a troubled division at that?
I know.
Why are you applying for this job? Is what I'm trying to get from you.
Thank you, Chief Justice. I will give an honest answer. I was actually nominated for the job, and the approach came to me as a surprise, and because I was still minding my own business, doing my work, being comfortable at the Supreme Court of Appeal. But I took to heart the confidence that was shown to me by those that nominated me, and I reflected on it, that they saw something in me that at this moment in time, you have something that we think can be valuable for you to contribute in the Western Cape Division of the High Court. And since I come from that court and are very much close to it, it is the court from where I come, I decided that I'm going to accept this because I believe that being a judge is an act of service. And so you serve as a judge. In isiXhosa ndiya apho ndithunywe khona. Loosely translated, I go to where I am sent.
All right. That's a nifty answer. Okay. Now, are you not worried that if you go back there, although you spent all those 7 years in your previous life there, you would practically be coming in from the cold? And how do we know that your appointment would not cause resentment and perhaps meet with resistance?
I'm not new in the court, Chief Justice. I know all the colleagues in the court. In fact, even the ones that were appointed after me, I had an occasion of interacting with them at the personal level. And I can safely say that a number of colleagues have actually called me and they've said to me, we are behind you and we are supporting you. So I know that there would be no resentment whatsoever when I go back to the court. And I kept in touch with the colleagues. I'm not new, and I don't think they see me as an outsider per se, because the time that I've spent away from the court is not too long. It was only 4 years. And I think that, Chief Justice, while we're there, I think as a person who has been outside of the court and now coming in, I would be bringing a fresh perspective and the manner and the way of seeing things in a new way, because I'm not too close to things that are happening there. And sometimes when you're not too close, you have a broader view of things.
All right. I don't know if you have a vision for the court if you were lucky enough to get appointed. What do you know about its current condition, and what plans, if any, do you have for it?
Thank you, Chief Justice. I have put my vision down, and if you would allow me, I'm going to read my vision.
Okay.
Thank you. My vision for the Western Cape Division of the High Court is first to ensure that we serve litigants and the public as our constitutional mandate requires of us. This means working to cut backlogs, making court processes easier, continuing to make the court accessible, and improving the court experience for its users. Secondly, it is about us who work in the building, the judges and the court staff. I want to cultivate or enhance a culture of collaboration, collegiality, openness, accessibility, and efficiency. It is to contribute to making that court a united and a transformed one, which would provide quality justice to the people of the Western Cape. Thirdly, is about collaboration with the stakeholders who are the users of the services of the court. Fourthly, working with the magistracy. Section 84C of the Superior Courts Act provides that the Judge President of the division is also responsible for the coordination of the judicial functions of all magistrates' courts falling within the jurisdiction of that division. So my presentation touches on these aspects. Why I accepted this nomination? This is the first time in 23 years that a new leader for the Western Cape Division of the High Court is being considered. When as I've said, Chief Justice, when calls came for me to make myself available for nomination for the position of Judge President, I heeded yes after some long and hard deliberation. This I did because I took to heart the confidence that those who approached me have in my abilities. I was humbled by that. I believe that I'm suitably positioned to lead the division and to set a vision for its future. I want to be part of building on the gains that have been made and facilitate any changes necessary for the well-being and development of the division. That court is where I learned most of what I know as a judge today. It is very close to my heart. I literally grew up there. I do not come as one with all the answers, but as one who would like to be part of the collective that will find solutions and cultivate a new culture. Before I went to the division in January 2013, I was warned about how difficult the place was and how I would be unsettled by the environment as an outsider who had not even practiced in that division. When I got there, I was warmly welcomed by all the colleagues in the division. This is partly due to my personality, I think. I have always enjoyed healthy relationships with colleagues. Like other workplaces, there were challenges, but at the heart of it all, no matter their differences, colleagues in the main worked hard. They were respectful and committed to the delivery of justice. They would not let their differences affect their public duty, which was to hear matters and deliver judgments. As someone who has been in the division, who had been in the division for 7 years and outside of it 4 years, I believe I have a unique set of both experience and skills to lead the division into its immediate future because I have an objective perspective about its present circumstances. I'm not new to leadership. Currently, I'm one of the 2 judges serving in the Rules Board as its vice chairperson, who together with the chairperson are responsible for leading the board. The Rules Board is a body that is charged with making rules for almost all the courts of this country. I'm also one of the 6 judges who are currently members of the Judicial Conduct Committee, a structure that oversees discipline amongst the judges of the highest courts in the country. Apart from the Chief Justice and the Acting Deputy Chief Justice, I'm the only other judge currently in service in that committee. I would like to think that I was appointed to these positions because I have leadership qualities. I'm a presider currently at the Supreme Court of Appeal. A presider is a senior judge who manages several matters allocated to them and other judges in a term. Members of a panel usually include acting judges. The presider not only directs the proceedings in court, but provides guidance on the approach to be taken in matters and assists junior and acting colleagues when consulted on substantive issues. Before I became a judge, I served in various leadership positions in the legal profession and in the society at large, as I've mentioned to the Chief Justice, including the South African Society for Labor Law, the Institute of Retirement Funds, Mine Workers Provident Fund, Vision for Women, which is very close to my heart, an organization in Port Elizabeth that inspires, mentors, and empowers young girls and women to know that they can be something better in life, and other bodies. I also manage a company that I was part of, and as well as a branch of a law firm of which I was a director. I also did management and leadership courses early on in my career. All that is in my CV. One of my other unique skills and experience that I would bring to the court is an emphasis on thought leadership, which would help strengthen the jurisprudence of the court. I've had the unique privilege of having sat in 4 different courts, including the appellate courts, the CAC, and presently the SCA. The advantage of sitting at the appellate court is interaction with colleagues who come from different divisions around the country. With this experience, I'll bring a broader and a richer perspective. At the SCA, we sit in panels in every matter, where one learns to respect and accommodate other views, and where we cannot find each other to disagree without being disagreeable. As a judge of almost 11 years and 13, including my acting stints, I've been a hard worker, and I believe I have a strong work ethic. I've led from the front in leadership positions I've held. I've never shied away from challenges. I've written judgments in complex matters, even as a junior member of a panel, in the High Court and in the appellate courts. I've also shown my independent-mindedness in that where I differed with colleagues, I would write separately, no matter how complex the matter was and how much time the research it would involve. At the SCA, I've had exposure and engaged in complex legal issues across the spectrum. Since 2020, I would have participated in approximately 10 to 12, sometimes 15 matters in a term, on average, translating to about 160 or more appeals up to date. The division is uniquely placed. It is in the province where the national legislature seat is. This presents it with an opportunity of nurturing the talent and cultivating strong jurisprudence in areas of administrative law and constitutional law. I would encourage continuous learning in the court by promoting the culture which I found when I first went there of senior colleagues assisting junior members. I would advocate for a structured induction and mentorship program to assist acting and new judges. In reviews, the division has always had a practice of having 2 judges sitting together. This can be a platform to pair a senior judge, a senior colleague with a junior one, for transference of skills, so that the inexperienced judge is not thrown into the deep end. I'm aware that there are two senior judges at the moment who had held workshops with acting judges. We will build on that. The division could have a judicial education committee, like the one in the Gauteng division, which develops a program per term by promoting peer learning workshops every Thursday lunchtime on topical issues. I know that the division has colleagues. I know that the division has colleagues who have vast experience in specific areas of the law. I would identify their strengths and weaknesses with a view to utilizing their expertise in the areas of strengths, but also to balance the allocation of matters so as to expose all colleagues to a wide range of cases in order to build capacity for the court to the advantage of the litigants. My focus will also be on enriching our judgment.
Where is this document? Do we have it? No. Oh.
No. Should I continue?
I thought. Huh?
Sorry.
I thought do we not need it?
Well, I've been listening very intently, so we can ask.
Yes, I can share the document afterwards.
Yeah,
I was not asked to make it available.
Yeah. Mayor Kulba, well, we didn't know you were going to read the document, so.
Okay.
Yeah. No, but you can make it available to us as soon as you can.
Yes, I will do so. Can I continue, Chief Justice?
Yes, please.
Okay. My focus was on this part, that my focus would be on enriching our judgment writing skills with an understanding that while judgments are primarily written for the litigants, they may also be precedent setting, and they are also used as teaching tools. The division has been for years circulating a list of reserved judgments, which works successfully to get judgments done. This is useful in keeping a watchful eye on bottlenecks and delays to ensure that judgments are delivered timeously. I would identify reasons for late delivery of judgments and find ways of assisting colleagues who have challenges as part of ensuring our accountability to the public. I would encourage colleagues, as I've said earlier, to upload judgments to SAFLI, as that is not consistently happening, and prepare media summaries for all important judgments. Transformation remains a key discussion issue for the judiciary. Western Cape has unique challenges on this aspect in both the legal profession and on the bench. Many Black African judges who became judges in the Western Cape did not practice in that province. The majority came from the other places. Now I'm including those that also have retired. Currently, there are few Black and women senior advocates at the bar, only 2 Black African men and no African woman who is a silk when I last checked the website. Their tennis profession suffers from the same lack. Commendably, very good Black African judges have been drawn from the magistracy. This is a good balance and shows that one need not only look at the practitioners. I would do my homework to also draw acting judges from the academia in the province and from elsewhere in the country. Transformation and excellence are not mutually exclusive concepts. They must go together. Given our unequal past, while we transform, we must mentor and develop skills in a structured way to get us all to the level that benefits the litigant. The immediate challenge in the division is working towards change in how colleagues relate to one another. We have to work towards creating a culture of openness, transparency, and cohesion, where we would build an environment of trust. I hope to provide leadership that is attentive, felt, visible, accessible, and collaborative. My role as a leader is to help others to do their work to the best of their ability. How will I facilitate this? I will visit each colleague in their chambers. I know this sounds simple. I will visit each colleague in their chambers to find out what the issues are, to open communication channels between the head of the court and the colleagues. We are human beings before we are judges. I would then encourage holding a boss parade, maybe with a facilitator, to talk about issues faced by the division. My hope is that in those conversations, we'd be able to carve out a vision for the future of the division, short-term, medium, and long-term. We would hold regular judges' meetings to ensure feedback, transparency, and accountability. I would like us to work as a team where colleagues are part of the decision-making process and the administration of the court. Involvement in committees is one way of achieving that. I'm aware that there are committees in the court currently, some more active than others. We would review their effectiveness with a view to enhancing them and creating more participation. I would suggest the creation of an elders type of committee, which can be made up of senior colleagues, including the judge president and the deputy judge president, or the chairs of committees, or any other formulation that colleagues may find suitable. This committee would discuss matters that require attention between the plenary judges' meetings. It may also advise on acting appointments, for example. I would also meet regularly with the court staff, as they are the backbone of administration. Collaboration with the chief registrar, court manager, and the provincial head is important. Courts are facing various challenges at the moment, central to which are shrinking resources, which affect the turnaround times for service delivery. The court does not have enough personnel in the registrar's office. It has lost a lot of personnel, and they are not being replaced. Interpreters resigned in numbers after lockdown. This leads to postponement in criminal trials. Backlogs in criminal trials remain a big challenge facing all the courts. As we heard when the former Chief Justice gave statistics in the Judiciary Annual Report for the period of 2022 to 2023, targets in all divisions were very low at 30%. Although many divisions outperformed their targets, the Western Cape sitting at 58%, of finalized cases for that period, backlogs remain unrelenting. Case management in criminal matters has been in place in the division for many years. There is, however, an increase in criminal trials. Even when certified trial ready, they cannot speedily be heard or resolved. So collaboration between the leadership of the court and the DPP's office to manage this is key. There must be discussion as to which matters should be coming to the High Court and when for proper planning. In turn, the operational consultations between court administrators, their operational counterparts at the DPP's office, as well as the police regarding operational matters in preparation for criminal trials should be installed. Collaboration is also required with the legal aid to streamline their decision-making processes when considering applications. As regards civil matters, judges are involved in case management and pre-trials are held every second week. I was part of that when I was there. There is a significant increase in CRASA matters, and we know the big elephant in the room are RAF matters and the creeping increase in medical negligence cases. And in my view, heads of court should engage with the RAF to find ways on how it can improve in bringing matters to court. The earliest dates available for allocation in civil trials, I was told, is in August 2025. The earliest date available for semi-urgent is in January 2025, but there are those set down for March 2025 as well. For opposed motions, matters are being allocated for February 2025. Case flow management remains the most effective way of weeding out matters that should not go to trial early on. But this must go hand in hand with mediation. Mediation, as you would have seen in my CV, mediation is very close to my heart. I'm one of the 7 judges who were sent to Utah to be trained as a mediator and as a trainer. We came back and conducted various workshops for judges, magistrates, and traditional leaders via SAJE, which was well received and well attended. Colleagues were given some practical tools of how they would conduct mediation. The idea was not to have judicial officers mediating all matters per se, but to sell mediation as an effective tool of resolving disputes, to equip judges with skills they could use in case flow management, and to encourage litigants, where appropriate, to opt for mediation. Mediation offers a lot of benefits. It is cost-effective, it may lead to speedy resolution of matters, and the solution comes from the parties themselves. Modernization and digitization will go a long way in helping with court efficiencies. Judges and court staff have been trained on case lines, and I was trained on case lines twice at the SCA, and I'm made to believe that the division is ready for the rollout. And that there will be a self-help facility that will be put in place in the court for those that cannot upload in their homes or in their offices. The rollout of case lines means traveling to court from faraway places to file documents will be a thing of the past. Judges and practitioners will have access to documents online wherever they are and in court. The system will also help with the archiving space, which the court is currently struggling with. Litigation is expensive. As part of enhancing access to justice, I would move for the creation of a pro bono desk manned by lawyers on a weekly basis, particularly for unrepresented litigants in motion court. I will collaborate with the legal profession on how this can be formalized and even recognized as pro bono hours for the benefit of participating practitioners. I will collaborate with the legal profession to listen to their concerns as recipients of our services and on ways of improving our systems. Circuit courts are key in bringing justice to the people. Ways in which we can make them more effective and accessible will be looked at. I would also look into the proposal by the Rationalization Committee, which I saw in the document, to make Thembaletu Circuit Court a local seat. I would interact with the magistracy to address issues beyond reporting at the PEEC. There are several challenges that need attention. For instance, the method of how posts are created in the Regional Magistrates Court is outdated. It was last reviewed in 2008. Regional courts are centered around the city and bigger towns. So regional court magistrates in those areas are expected to service other areas which are not as small as they were in 2008. For instance, a magistrate from Cape Town would go for only 5 to 10 days in a month to Hermanus, which has about 200 criminal cases. Why can't a post be created in Hermanus, for instance? Hermanus is not the only place, there are other places as well. The attainment of a single judiciary is imperative. The magistracy needs to be supported by the judiciary beyond case flow management and coordination of statistics. I would add my voice to the calls for full institutional independence for the judiciary and the better resource judiciary. Thank you, Chief Justice and Commissioners, for listening to me.
Thank you, Justice Mabindla-Boqwana. That's a lofty and all-encompassing vision, I must say. But have you been, well, you've given us a lot of intimate detail that seems to suggest that you've been in touch with the court.
Yes, I have.
To get an accurate sense of its state.
Correct, Chief Justice. I was in touch with the court administration to get correct information as to what is the state of affairs with regards to court administration. I also was in touch with colleagues in the division just to put me up to speed, because it was necessary for me to have those details for the purposes of understanding what the current circumstances in the division are.
Okay. You do many things, and some of those holding the position of Vice Chairperson of the Rules Board for Courts of Law.
Yes.
And you're also one of the 6 members of the Judicial Conduct Committee of this body.
Yes, Chief Justice.
Okay, well, you mentioned mediation as one of your passions. You did not mention that you also train judges.
Yes.
You have trained and trained judges in cybercrime and competition law as well.
Yes, yes. When, I think that was a few years ago, before there was still a cybercrime bill at the time, and there was a European team that came, I just can't remember their name, that they came via SAJE, and they trained judges as trainers, and then we had to train other judges, or at least sensitize them, maybe not train, but sensitize them about cybercrime and what it is all about.
All right. Well, it's impressive that all the professional bodies support your candidature, and they speak very highly of you. The GCB saying you have a reputation for integrity and ethical behavior, and you are a well-respected judge in the Cape Division, especially among practitioners, so that's quite a compliment.
I'm humbled by that, Chief Justice.
Yeah. All right. I will leave it here for now, Justice Mabindla-Boqwana. Judge Gamble, do you have questions for this candidate?
Thank you, CJ, and good afternoon.
Good afternoon.
Former colleague, if I may say, Judge Boqwana.
Good afternoon, Judge Gamble.
Your list of judgments is impressive, to say the least.
Thank you.
You've covered all areas of the law. My eye falls on matter number 28, called the Polaris. Do you remember that matter?
I remember it.
We had an interesting discussion about it at
Yes,
the time,
I
because
remember.
it was a shipping case that crossed over into business rescue.
That's right, yes.
And I see that you say that that's been internationally acknowledged now.
Yes, I actually stumbled on it sometime on a publication that was done, and I was interested, and I read it, and I found that, in fact, it was a subject of the publication, because it talked about the intersection between company law and
shipping law.
Yes.
And for those who don't know, Cape Town has a very busy shipping practice. The
That's
Cape
right.
and Durban courts do a lot of the shipping matters.
Yes.
I dare say this is one of the first judgments written by an African black woman on shipping law, and that was quite a ceiling to break through.
Oh, I didn't know that.
Judge Boqwana, the question that I and many of your colleagues are asking is, why are you moving south rather than north?
I think there's a pool.
And I ask that with respect
Yes.
for the following reason. Your acumen lies in research and strong judgment writing. You occupy, I think, a fairly senior position in the SCA now, and you've led panels there. that court is going to be depleted. But many see your future in the Constitutional Court. Do you have any long-term goals in that regard?
You know, Commissioner, it's very difficult to actually answer that question at this point in time, because 3 years ago, was it 3 or 4? 3 years ago, when I sat on this chair, I did not know that I would be sitting on this chair again today. But one thing I can say is that I'm committed, you know, were I to be appointed in the High Court as a Judge President, to stick around and stay in the High Court, because one thing I can commit to is that I will not abandon the court, because I'm committed to making sure that what I envisage myself doing and contributing at the court is brought to pass, and I can see it being successful.
If I look at your personal details in paragraph 4.1, you just 51 years and some months, and you will have completed with your appointment, if you're successful, just over almost 11 years. You would then be entitled to exit at 65, would you not?
Yes.
Because you will have done 20 years. So the minimum period that you would be in the court would be 13 years?
Well, for me, I don't look at 65 for now, because I'm not about to retire, so that's not even something that I'm thinking about. So when I think of retirement, I think 70 somewhere down the line.
Let me assure you that when you get to 64 and a half, you'll be thinking very seriously about the 20-year option. But jokes aside, you could exit after 13 years.
Yes.
Failing that, you would have been in the position for approximately 18 years. That's
Yes.
if you went at 70,
Yes.
which is the maximum
That's right.
period that you could. During that time, you are going to be involved, as we've heard this morning from the other colleagues, in a considerable amount of administration work.
Yes.
And my concern is that we will lose your contribution to the jurisprudence, because you're going to have a lot more on your plate. Obviously, you will go in and sit in the big cases.
That's right.
That's what judges president should do.
Yes, and that's
They
what I
haven't
would
always
like
done
to
it,
do.
but they should do it. They should go in
Yes.
and lead the judiciary on the jurisprudential side.
That's right.
And that would be my concern, and I'll give you a chance to think about it. That you're going to lose your contribution. We're going to lose your contribution to the jurisprudence at the cost of administration and fixing broken toilets and things like that.
If you've seen my path, Commissioner, as we were discussing with the Chief Justice, I consider myself an all-rounder, because I didn't just go and practice law. I did a lot of things, and that makes me a person who's actually well exposed into many things. I don't see being a judge president as administration in the sense of doing, you know, small things and tasks like that, and maybe allocating matters and all that. I see it as a broader thing, because it is a leadership position where you set the tone, not just for the court, in how the culture, yes, the jurisprudence, also the province, because you take along the magistracy with you. So it is a position that is broader than just administration.
And then, excuse me, lastly, you will inherit, and if you get the position, you will inherit an incumbent deputy.
Yes.
Who has been in a leadership position as a deputy for 8 years, I think, 7 or 8 years.
Yes.
And in a leadership position for 2 years. Do you foresee any problems between cooperating with Deputy Judge President Goliath if you get the position?
Not at all from my side, definitely not, Commissioner. I've known Deputy Judge President Goliath for a long time, since I was in the division for 7 years. And I've had a number of interactions with her, and I respect her. I think that the position of the Deputy Judge President is an important position, because it is not only a supporting role to that of the Judge President. The Deputy Judge President has tasks that are generally allocated to them by the judge president. But besides that, when the judge president is not available for whatever reason, the deputy judge president does the job. And so it's important that we work together effectively and in a matured way. And that is something that I commit to do.
And there are no issues between the two?
There are no issues between us.
Thank you. Thank you, Judge Boqwana.
Thank you.
Thank you, CJ.
Thank you, Judge Gamble. Mr. Boshoff?
Thank you, CJ. Good afternoon, Judge Boqwana. Right here.
Okay.
At the risk of I don't want to repeat Judge Gamble's questions to you, but so a friend of mine once said to me when I was bemoaning my career paths, etc., he said, you know, sometimes choice is a curse as well. And I just want to inquire a bit about your career path and your decisions in your career, and please see it as a compliment, because clearly your membership of the judiciary is something we should all be very grateful for. The world is your oyster, so to speak. Now, you mentioned that there was a potential, possibility for a leadership role at the Competition Appeal Court, but that was then overtaken by your current, the opportunity that you then pursued at the SCA. May I ask why, and is my suspicion correct that the SCA was seen as academically a bit, more challenging and satisfying potentially? Or what informed your decision to, instead of pursuing a leadership role at that position, at that point, to pursue the opportunity at the SCA? And then with regards to now, the potential for, within the near future, opportunities at the Apex Court arising, what then informs your decision to rather pursue here? Because, and this brings me back to choice being a curse, whatever you were to pursue, I'm sure you would succeed at. And with a potential career span of 18 years still ahead of you, what assurance do we have that 5 years from now, you won't be sitting here again, or in 3 years from now, for an opportunity at the Apex Court?
Okay.
And that's just within the context of a division that really urgently requires long-term stability and long-term commitment. Thank you.
Yes, thanks. Let's start with the first question about the Competition Appeal Court. There were no firm discussions at that time between myself and the Judge President, Dennis Davis. It was just a futuristic thing that this is something that he would like me to do in the future. So it was not something that was colliding per se at the time. And so, and the other reason is that the Competition Appeal Court is a specialist court and doesn't open you up, so you would be dealing with just one area of the law. Yes, you'll be in the High Court as well, but at that point, I thought being at the SCA, where you would learn a lot more, would be something that I would like to do, and that is why I opted for the SCA. I didn't think about it in that sense at the time. And I mean, I want to repeat my commitment when it comes to me now being approached and having accepted to be considered for the Judge President position of the Western Cape High Court, that my, what I'd like to do is to have that division coming to the stability that will make everybody happy about where it would be at the time. And I would not abandon the division and just simply fly away and say, well, because this is not about a personal ambition, because even moving from the Supreme Court of Appeal and coming here, it is not a personal ambition issue. It's about people thinking, we need you more here, and me saying, okay, I'm going to accept that call.
Thank you. CJ, just with your indulgence, I mean, I know it wasn't one question, but if that
No,
could be my first question.
Ask away.
Then just the second question.
Chief Justice, I wanted to make a follow-up on what he said.
All right,
Okay.
you
Yes,
can interpose.
on the first one, yeah. Mine is very quick. President Molemela was interviewed like you for a position of JP in Free State.
Yes.
And in a short space of time, she went to become the president of this SCA. Did that court of Free State collapse after that?
No, it didn't.
Thank you.
It was left stable. Thank you, Commissioner.
Carry on, Mr. Bosho.
So Judge, you would be aware of the objections filed during this process, and you filed a response, quite a comprehensive response.
Yes, I
And
did.
I don't want to go into the detail of it.
Yes.
I think my question is just that the complaints centered around your relationship, professional engagement with court staff and support staff and administrative staff at the division. Were you to be successful in this process, you would obviously have to work with some of the people at the center of this objection and your response on a daily basis. How do you propose to mend those fences or build those bridges again? You know, because it was quite an unpleasant to and fro, and I don't want to breathe life into it. I just want
You are
to.
actually not allowed to breathe life into it because the objections committee of this body, it deliberates on all the complaints that come against candidates. It carefully adjudicated that matter and found that it had no merit and made a decision that is binding on all of us not to put questions about it to the candidate. And this is not just unique to this candidate. It serves for other candidates who've come and are still coming.
CJ, my understanding is that the committee dismissed part of it that had the double hearsay attached to it, but that the remaining, there was the other half of it that they were comfortable with us, but I will defer to the committee to confirm or correct me there.
If that is the case, then you are most welcome to ask on the uncontroversial part.
CJ, the point is, that's why I say I don't want to go into the detail of it, but clearly whether it's whatever might belie it, the candidate will be, if successful, be going into a division where there is this, for lack of a better term, thing in the air. And I would just like to,
No,
just from a leadership point of view, find out how she would address
There
it.
wouldn't be, actually, because those people are not in the court. The people who wrote in are not in that court.
Well, one is.
No, he's not.
No, both of them are not in the, well, the one was never employed, the other was an ex-employee. We dismissed the first one about the widower completely. The second one is relevant insofar as a general point about not the complaint, but whether or not Judge Boqwana has a good relationship with staff. That's open to us.
Perhaps given that there isn't really a delicate way of then asking the question, I'll rather abandon that line of
No,
questioning.
I would not want to deprive you of an opportunity of putting a question you think is worth asking, Mr. Boshoff. As I said before, you may ask on the part that the objections committee has said we may ask.
I think maybe then, I'm just not comfortable going down that line and perhaps overstepping, CJ.
Yeah,
So I'm
it's
not
tricky.
comfortable doing that.
Okay.
I don't think it'd be fair to this process.
Okay. Thank you then.
Then I have no further questions.
Okay, thank you. Commissioner Malema, I don't know if you had
No,
a
it was
substantive question.
a follow-up,
Okay.
yeah.
Commissioner Marumakhai?
Thank you very much, CJ. Good afternoon, Judge Boqwana.
Good afternoon, Commissioner.
Since these interviews have started, a lot of people have been asked in terms of their trajectory and their history of assisting people from disadvantaged backgrounds, and their role as they progressed, taking the village with you kind of a situation. And even some of the candidates who are actually trying to get this post, they've been asked if they are successful, what is it that they are going to do to make sure that all that we are complaining about, briefing patterns and all these kind of things, at some level they are addressed. I want to ask on that sense that in your own journey of success, which is quite remarkable, what have you done to ensure that as you progress, those who were at the bottom, you actually carried them with you going forward? And when you get the post, what is it that you are going to do to contribute to the debate that people from disenfranchised sort of communities, they deserve to be given opportunities to showcase what they can do? I mean, you in your vision, you referred that at the Cape Bar, for instance, there are 2 males who are senior counsels, and there is no, so those are the challenges that we are faced with. When you assume this leadership role, what will then be your role? But I'm interested first in your journey before you answer the second part of the question. Thank
Chief
you.
Justice, could I just intervene here? Could I ask the Commissioner to rephrase 2 questions, which is when you get the post to if you get the post?
Oh, thank you very much, Commissioner.
I missed
If
that.
you get a post. Thank you very much, Commissioner.
Thank you so much, Commissioner. I take keen interest in actually mentoring. I take keen interest in mentoring, particularly women, because I believe that I'm where I am because other people took me along with them and mentored me. And so I don't only talk and give speeches in conferences and workshops and seminars. I have one-on-one mentorship. I have people even currently that I mentor, and actually someone that I bumped into also here said to me, Judge, I think she's applying for a position. I don't know if it's tomorrow. She bumped me and said, Judge, I remember you held my hand and you said, you know, that's fine. We want to hear your voice in the judgment. And you showed me the ropes when I first came to act in the court. And so that is what I do. And when it comes to the Western Cape has a difficult or a different kind of scenario as compared to other places. Other places, you will be able to find a professional African person everywhere you go. But in the Western Cape, you don't necessarily get them readily there, or you don't see that they probably are there. So one of the first things that I would do is to actually interact with the legal profession, that we may go and find people, because I believe that there are people in the corners. I was also found in some corner in Port Elizabeth. So we need to collaborate with the legal profession to try and find people, one, but also not to do only to do that, but to mentor people, because you have to understand that we come from an unequal past, and therefore we need to pick each other up, and so make sure that we are exposed in these kinds of areas. But the third thing is that I think this discussion also involves businesses, clients, and so it's a legal profession, and people that give instruction and brief people that must be involved in this debate. I'm talking about big business and I'm talking about big firms to be involved in these discussions so that they can influence their clients to brief and give instructions to black people and give them a chance.
Thank you, CJ.
President Mulemelo.
Yes, thank you very much, CJ. Good afternoon, my sister, Justice Mabindla-Boqwana.
Good afternoon, President.
Just to record that you and I met for the first time in 2012 when you were still acting at the Labor Court. Is that correct?
You're correct. You borrowed me your bib.
Yes. And we have had a cordial relationship ever since.
Definitely.
I'm just saying this just to clear the air that you are not running away from the SCA.
No, not at all, not at all, President.
Yes. You'll confirm that you and I have had several conversations
Yes,
regarding what I thought would be your career path.
yes, that's correct,
You,
President.
in your mission, reference was made to your strong work ethic, and I can attest to that. And it was precisely because of that we had several conversations along the lines of your career path.
That's correct, President.
Also that after being nominated for this position, you called me and we had a long conversation, and you indicated that you wanted my views before finally accepting the nomination.
That's correct, President.
Yes, thank you. My last question. You alluded to the fact that you were attached to Tukiso Dispute Resolution Center at some point as a mediator, and that
Yes.
you attended a seminar in Utah on mediation and so forth,
Yes.
and mentioned that only in relation to the importance of mediation as an alternative to adjudication or ADR.
Yes.
Yes, but if appointed, do you think that your experience as a mediator would come in handy in terms of healing the rifts among colleagues that currently exist in that division?
Definitely, President, because mediation is about pulling people together who are in conflict, and you have the skills of being able to ask the right questions and to assist parties to finding a solution. So I believe that those skills would definitely come in handy.
Thank you, Justice Mabindla-Boqwana. Thank you, CJ.
Thank you, President.
Thank you, President.
Commissioner Gotzel?
Thank you, CJ. I do have a question, but before I ask it, I just want to go back to Mr. Russell Daniels, and I will try my best not to overstep. Good afternoon, Judge.
Good afternoon, Commissioner.
Judge, do you know Mr. Russell Daniels?
I know him as an usher who used to be at the court, so I know him like all the ushers in the court.
Yes. Now, is there any reason why Mr. Daniels would fabricate such a story?
I don't know, I'm also shocked. I was actually taken so much aback, so I don't know what...
Commissioner Gotzel, the decision was that the candidate would not be asked about that objection because it was adjudicated and found meritless. So we can't put questions by our own resolution. We can't put questions to this candidate about that objection. That's how this works. That you do have the policy, the objections policy of the Judicial Service Commission.
Yes.
Yeah. You can't put those questions.
All right, well, I'll move on then. So, Judge, you've been in the Western Cape High Court for 7 years.
Yes, I was.
And how much criminal experience did you gain in that time?
A lot. In
a lot of-
fact, in my
okay.
first year of acting, I was involved in a criminal case, and it involved rape and murder, and a case where I had to impose life. That was my first criminal trial, and I've done criminal trials a lot in that court, criminal appeals from the Magistrates Court, and also currently do criminal appeals at the SCA. So in my 11 years, I've done a lot of criminal work.
Okay, so the Western Cape is plagued by gang-related matters, quite a lot of them.
Yes.
Some of them will probably take multiple years to conclude,
Yeah,
and that attributes to the backlog of the criminal role.
yes,
At the same time, the Department of Correctional Services also has a massive problem with remand detainees.
yes,
So in your vision, you explained that you would liaise with the DPP, the legal aid, and other stakeholders to address the backlog in the criminal role, but I was just wondering if you could maybe just explain how you would also work with the magistracy and the Justice Department and perhaps Correctional Services to encourage AVR technology, electronic hearings, in order to address the issue regarding remand detainees.
yes. I think that's important. I would work with them to make sure that when it is not necessary for a matter to be physically in court, then we can deal with those matters in that way. So I would collaborate with them.
Thank you.
Commissioner Matolo-Lepo.
Chief Justice, just to follow up, not on the crime issue, but on that first issue.
Okay.
Just to, for those commissioners who were not with us when we began, we reported on the matter that the 2 objections were considered and dismissed. We then said it is still open to ask the candidate whether or not they've got good relationships with staff, because it's an important aspect of leadership. But the objections were both dismissed. And that is why the Chief Justice keeps reminding commissioners of our own decision in accordance with our own objections policy.
Exactly.
Commissioner Matolo-Lepo, thank you for the intervention, Commissioner Nugaito.
No, thank you, Chief Justice. Good afternoon, Judge Boqwana.
Good afternoon, Commissioner.
No, just to put on record, the question by Justice Mulemela was the same question I wanted to ask.
So you covered?
Yeah.
All right, thank you, Commissioner. Commissioner Hassan?
Thank you very much, CJ. Judge Boqwana, let me start by first addressing some of the important cases you've presided over, and I think it is just relevant to mention it. Also as a Muslim woman, as someone who does represent that community quite often, and just to say how important and how groundbreaking it's been. I mean, even my own grandmothers and many members of my community have for a very long time been fighting for recognition. So I think it's just important to acknowledge the activist role and nature of some of those cases. But to my question, CJ, through you, I'm very interested in, and I picked up pieces of it when you were relaying your vision, but maybe it's just a little bit easier to speak to it now. There are 7 senior judges in the Western Cape Division who will retire in the next 2 years.
Yes.
And I think it's cumulatively almost 100 years of experience. And another candidate also mentioned this. So I'm interested in your views around how to build a strong pool of succession, but also what you will do beyond the regular run-of-the-mill acting stints and sort of going on courses. I'm very interested in that, and perhaps related somewhat, if you could also bring in the rationalization project, which is quite a big thing ongoing in the judiciary. Thank you.
Thank you. Thank you so much, Commissioner. The first one, I think it's important to use the skills of the retired judges by making sure that we bring them back to assist with workshops on important topics, and also to call the judges back for important matters where they can sit and transfer skills to junior colleagues. One of the things that I think might be important relates to criminal trials. Where we have a backlog, one of the things we could do is to recall or maybe ask retired judges and perhaps regional court magistrates that have retired to assist with the backlogs, perhaps during recess periods, because of the shortage of courts that we might have during term. And so we need to utilize those skills and not simply let the skills go without being tapped into. When it comes to the acting stints, I think it's important not to develop people only by acting, but educating. So there should be education, not only of acting judges, but of judges themselves, because we have to continue to learn, because things keep changing and adapting and developing. So I would encourage, as I've said, continuous learning, and it must be structured. Induction programs must also be structured. The last question was about, can you just repeat the last question?
The rationalization. Let me actually phrase it properly, because I do have it here, about what you can do to enhance access, more particularly to the poor and marginalized, taking into account the rationalization interventions and projects that's ongoing in the judiciary. Thank you.
Thank you very much, Commissioner. I think one of the things that's mentioned in the rationalization report is whether or not the Western Cape should have a local seat, because currently we have a main seat in Cape Town. and that is the only one. And then we have circuit courts around, and we have Thembaletu in George, which sits 5 weeks a term, that also services places around it. And so I think having a local seat will bring access to justice to the people who don't have to come to Cape Town, and saving on transportation and all that. I think it's important also, there was something else that was mentioned in the report that had to do with concurrent jurisdiction that needs to be addressed. I haven't thought through it as to exactly how the issue of concurrent jurisdiction between the magistrates' courts and the high courts, that you find a situation where a plaintiff picks a court. They would normally pick a high court because they think that the high court is more efficient and they'll get speedy justice. Now, the defendant has to travel all the way to the high court, and in a matter that could have been dealt with at the magistrates' courts level. And that's the first thing. And the second thing is the defendant will have to get lawyers and pay them at the rate that is higher than that which they give. I know that the courts normally give the scale when they give costs, the magistrates' court scale, but that doesn't address the issue. So those are the things that we need to think about as we rationalize.
Okay. Judge President Mlambo.
Thank you very much, Chief Justice. Good afternoon, Judge Mabindla-Boqwana.
Good afternoon, Judge President.
I think, Ashu, you've already mentioned that the first time we met, you had already accepted an acting invitation to the Labour Court.
Yes.
On that last issue, the Concord and the SCA have already said the High Court has no choice. Whether
Yes.
the matter is a match court matter, it must hear it if it comes to the High
Yes,
Court.
I understand. I've read that judgment.
Unless
So-
you will pull some magic and help us.
Yes, no, I think for me, it's more about perhaps education, Judge President, and for people to understand the benefits of having the matters being heard at the place that's closest to the people than getting people to travel all the way to the High Court.
Yeah. I heard your vision. I listened very attentively. Do you actually know what is the problem in the Western Cape Division?
Judge President, I was part of the court, and then there are historical issues in the court.
Yes.
That happened when I was still in the court, dynamics, whether overt or covert, but intentions and all that. So there are issues that I know, and some of the issues that came to the public domain happened at least the first 2 months that I was still in that court. And so I do know what the problems are in the court, and I also know it because the colleagues have kept me informed about the court, because I'm interested in knowing what the problems are.
Okay, thank you very much for that. Now, it appears on a case flow front, there's a problem in terms of a skewed capacitation reality, in that more judges seem to be required to do criminal trials than civil work in particular. I'm not sure if you are aware of that dynamic, and
Yes.
if so, what will you do if you are appointed to address that problem?
Thanks, Judge President. I'm aware of the problem. I think maybe before I answer the question of what would I do, maybe I should say the consequences of that problem are that the permanent judges that should be developing the jurisprudence of the court are taken away from civil matters that are important because of the problem. And you get acting judges coming on an ad hoc basis, and there's no continuity, therefore, and development in that regard. And so that is for me an issue that we would need, were I to be appointed there, that is an issue we would need to focus on, because we have to get continuity and empowering also, so that even judges within the division get a fair spread, a wide spread of matters. And then when it comes to my ideas on how we can deal with the criminal backlog, the first thing is an obvious one, which is the strong relationship with the DPP's office, because it's important for that discussion to take place, that some of these matters are not supposed to be in the High Court. There are simple matters that are supposed to be at the regional court, because I think the regional court, in my own view, is the court that is supposed to be the trier of facts, basically, on criminal matters. And what it robs of, what happens when when a simple matter comes to the High Court, that accused is robbed of an automatic right of appeal, because when the matter is set in the High Court, they have to apply for leave to appeal, as opposed to when the matter comes from the regional court. And so that relationship between the DPP's office and the leadership of the courts is very important, and it must be tightened up. The second issue I was told that there was a pilot project in the court where the court identified one accused, the matter where there was just one accused, matters that could just be removed from the roll swiftly. Those matters, as I think I've already mentioned, that we perhaps can have a project where we have retired judges and retired regional court judges and perhaps practitioners that could do that, but during recess, maybe deal with those simple matters that we can get off the table quite quickly. Those are just maybe the short-term things that we can do.
Thank you. CJ, I don't know, I still have a question unrelated, but I have a follow-up to this one.
Okay, ask the questions you have, JP. I'm
Ask
sure
them.
they will be. Ask.
Thank you.
You are a head of court, so you hold a special status.
Thank you very much. The follow-up question relates to the overall responsibility of a JP in a division.
Yes.
You also have some oversight responsibilities over the lower courts.
Yes.
The regional courts, I'm sure you heard from Commissioner Gottsel, I don't know whether he asked that question or maybe he didn't, that awaiting trial detainee periods are a big problem in the regional courts. They spend years on trial before their matters are finalized. It will be something that will be your responsibility as head of the division to try and assist. Do you have any ideas how you could do that if you are appointed?
I think, Judge President, we could look at the causes, maybe first whether we have enough people, enough complement of the regional court magistrates. As I've indicated, I think that with the establishment, what is currently being used in that regard is outdated. So we need to review that, look into reviewing that. And also, secondly, to look at the bottlenecks, what are the causes of inefficiencies in the system that make matters, that create the backlogs. And so that is how I would, for now, that's what I can think of, Judge President.
Thank you. Thank you very much. My last question. The high courts have a problem with reserve judgments. I'm sure you've read about that in the judicial reports and in the reserve judgment reports that come out periodically.
Yes.
I think the problem in the Western Cape is not as pronounced as some courts like mine.
Yes.
But do you have any ideas what you would do if you got the job to ensure that judges deliver their judgments at least within reasonable times, taking account of the fact that we don't have judgment writing time, unless you look at recesses?
Thank you. Thank you, Judge President. I would identify what is the problem, why the particular colleague, maybe I'd look at the pattern as to how many colleagues and who are these colleagues who tend to have judgments reserved, and go to the colleagues and try and look at ways in which I can assist them. If it is a matter of capacity, maybe alleviate some of the pressure to them so that they can be able to do the judgment. I know what used to be done sometimes is to give a judge a trial, a criminal trial, because when a person does a criminal trial, they've got some flexibility in playing around with their time that they can use to also write the judgments.
Thank you very much for that. Thank you, CJ.
Thank you, JP. Commissioner Notice?
Thank you. Good afternoon, Judge Boqwana.
Good afternoon, Commissioner.
There's just one question. I think you have touched on this in your plan, but it keeps on going around. What is your view about the importance of a good relationship with the staff? That is, I think we have touched on that, but if you can speak to it just again.
It's very, very important. I mean, the staff, they are the core support of the judges. So they are the backbone of the administration, and they help the judges to do their work well. And so it's important for judges to have a good relationship and take keen interest in the people that they work with. Not just being interested in the work they do, but being interested in them as a person.
Thank you, Judge. No question.
Commissioner Baloyi?
Thank you, CJ. Good afternoon, Judge.
Good afternoon, Commissioner.
Yes. Judge, you spoke about mediation.
Yes.
And that you've trained, you provided training to judges after you attended the mediation course. Now, could you share with us in how does it get practicalized? It's obviously a well-intended dispute resolution mechanism, alternative dispute resolution mechanism. We have it in Rule 41A. But when one looks at Rule 41A, at least the first parts of it, it's more a mechanical process where people indicate whether they want to engage in mediation. My experience is that generally litigants seem to prefer to choose not to go to mediation. What do you see yourself doing if you're appointed to this position to practicalize this alternative dispute resolution mechanism whose purpose is to move or at least to ease the backlog in the courts?
Thank you, Commissioner. As I understand, there is thinking to move towards court-annexed mediation at the moment, and we are currently awaiting legislation to indicate what kind of model would we have in our country. Would it be a hybrid model of having, for instance, I almost said commissioners, mediators coming from the outside privately, or would we have a CCMA type of thing where you have people employed within the system and assisting? The training that we did was not to make judges necessarily mediators, but it was to assist them with the tools, one, to get them to know what mediation is all about so that they can sell it to the litigants in front of them. So the judge would not just say, well, this is a matter that needs to go to mediation, but the judge will be able to say why mediation is important in circumstances like this. I had an example, but maybe I should leave that one. Rule 41A, I know that it is seen by a lot of people as just a tick box exercise because someone fills in a form, no mediation, yes or no. But it is really something that is meant to nudge people to think about mediation deeper, and perhaps a judge can assist in educating people there about mediation at case management level at least, because I think those two should work together. So I would encourage mediation in that way, that at case management level, in matters that are deserving, family disputes and other matters, please let's engage meaningfully with the parties as to whether or not mediation is not appropriate, and tell them what the benefits of mediation are.
Thank you, CJ.
Follow up, CJ.
Sorry?
Follow up.
Who's that? Oh, Commissioner Mabindla-Boqwana. Yeah, go ahead.
Thank you very much again, Judge. On the issue of mediation, obviously, even in the rules of court now, you have to show some interest in mediation at the High Court before you institute the matter. And obviously the magistrate court, there is court annexed and all those kind of things. But isn't it that mediation is now going the route of arbitration, where we see the mushrooming of private organizations that are doing, especially in family law, that are doing mediation, and the costs associated with mediation are contrary to how mediation has been advertised? Are we not experiencing that challenge now?
That's true. I mean, I think that's an impediment for many people who think that, well, at this point, I have to pay for the mediator. I have to pay for the cost of mediation. And I think that's one of the things we still need to think about creatively, is how to do. And if I recall the land court at the moment, there is a provision for costs, and it's not the parties that pay for the mediator. We still have to devise rules as the rules board as how the mediators will be paid. If I recall, I might be wrong. So I think you're correct. It is actually an impediment for many people, and we have to find ways of how we can be able to make it less cost, to be cost effective rather.
Thank you very much, CJ.
Thank you, Commissioner. Just one last question from me, Justice Mabindla-Boqwana. One of the judgments you list as your reported judgments is the case of Lungisa versus S, which is bilingual. You wrote it in English and isiXhosa.
Yes.
Is this, and by this I mean the practice of writing court judgments in our indigenous languages, is this something that we should encourage, and is it a practice that you would enforce at the Western Cape Division of the High Court if you get this job?
Definitely, Chief Justice. I think there should be recognition that all 11 languages are constitutionally recognized and entrenched, and promotion of language is important. So I would definitely inculcate that and encourage us as much as possible to make sure that we write judgments in the language that people understand. And maybe not just judgment writing. Proceedings in court could happen in the language of the people that are there if all speak the same language. But I understand the issue of cost because of the translations that have to be done for purposes of an appeal and all that kind of thing. But we should work around those things in order for us not to lose sight of the promotion of language.
Thank you, Justice. You're excused.
Thank you, Chief Justice and the Commissioners. I appreciate the opportunity.